Hello and welcome to Elville and Associates and the law offices of Gary Greenwald's 2020 client event on-demand video presentations. Thank you for joining us. We're pleased to have Mr. Stephen Elville, Managing Principal and Lead Attorney of Elville and Associates, and Mr. Gary Greenwald, Principal and Lead Attorney of the law offices of Gary Greenwald with us today as they share their annual general legislative update with you. Stephen, Gary, I will turn it over to you for now.
Thank you, Jeff. And I just want to say hello to everyone, a virtual hello. Gary and I are sitting here socially distanced in our conference room in Columbia. And Gary's going to come on the broadcast here very shortly. And Gary's going to do the general legislative update. I'm going to make a few comments about the new elective share law and the augmented estate that I have talked to so many of you about. But now that is law, and we're going to talk about that. So I just wanted to say, and I'll speak for both Gary and I, we wish all of you the very best. We are sorry we can't be in person with you for this very special annual event, our client event that we all love so much. So we're looking forward to the time when we can get together again in person and really celebrate our annual client event and education process. So with that said, we're going to launch right into the legislative update. So let's talk about the augmented estate, or what we will now call officially the new spousal elective share law. So this has estate planning implications for conventional routine estate planning between spouses. It also has an elder law context, which I will talk about briefly on both of those counts. So what we want to be concerned about here in estate planning is this new law that says that a surviving spouse has a right of election to receive at least 1/3 of the augmented estate. And the augmented estate, in simple terms, means not just the probate estate, not just the assets passing through probate, but a broader estate that would include revocable living trusts, assets, and IRAs, and so forth. And it's pretty complex, so I'm going to try to keep it simple. There is a formulaic approach, which is one of the reasons this law did not pass for so many years in the legislature, but has now passed. And basically, we come from a position where spouses 25 or 30 years ago were not protected from a spouse passing away and not leaving them at least 1/3. There was no good protections, to make a long story short. And now the pendulum has swung all the way to the opposite direction, where there are very substantial protections for surviving spouses. And we have to be aware of that, not only on the estate planning level, but on the marital protection level, let's say, in a sense of asset protection and protecting children, and understanding the rights of a new spouse or a surviving spouse. But most of you on this video call and this client event webinar are not really going to be affected by this, because most of you, the vast majority of you, are leaving assets either outright to a surviving spouse or for the benefit of a surviving spouse in a trust of some kind. And there is really no question that you're leaving basically 100% or close to it for the benefit of your surviving spouse. There are exceptions to these general rules of thumb about how most spouses leave almost 100% of everything to each other. But I want you to be aware that the new law basically says that if we don't meet the formulaic requirement that the surviving spouse, I should say, gets at least 1/3, then there will be adjustments. So we just want to be aware of this law. It won't affect the vast majority of you who are doing very conventional or traditional type of spousal planning. If you're a single person, this law does not affect you. So I just want you to, doesn't directly affect you right now, but I am speaking mainly to spouses right now. So we want to be aware that a surviving spouse has the right to 1/3 of the augmented or total estate. Now, let's talk about asset protection in the context of how to protect ourselves as we get older many of you have planned for leaving assets in trust for a surviving spouse. Now, why do you do that? Well, it's usually because we want to provide asset protection for a surviving spouse in a trust versus outright distribution. But the other underlying reason is to make sure that assets do not go to a new spouse. So the assets go to the surviving spouse in a trust, and then at the surviving spouse's death, those assets come down to children, grandchildren, nieces and nephews, and other beneficiaries. So the deceased spouse has some level of control. So that, as you know or may know, is the first level of control for how we leave assets to spouses for many people, and basically controlling those assets for purposes of what if our surviving spouse were to remarry, and if they were to remarry a new spouse. So that's kind of the first level of protection. Now, going back to the new spousal elective share law, what do we need to be concerned about? Because the new law is effective October 1st. The new law is effective October 1st. We've been talking about it now for the last 7 or 8 months, but here it is. It's effective October 1st. So it is the new law. And here's basically how I would characterize what we need to be concerned about if our surviving spouse were to remarry. Now, many of you know me, and you know that we've discussed these kinds of things. I'm sure Gary has discussed it with his clients. We've talked about how most spouses will say, well, I'm really not going to ever remarry. But we know that statistically about 8 out of 10 men remarry, and about 5 out of 10 women remarry. So a lot of people do remarry. So let's just say this scenario were to occur. You don't think you're going to remarry, but you do for whatever reason. And now here you are remarried. Well, what do many spouses do when they remarry? So the surviving spouse that remarries might say, well, I'm leaving everything to my children or to my beneficiaries at my death. I'm really not going to leave anything to my new spouse. And hopefully the new spouse, he or she is financially well off, maybe or maybe not, but maybe they're going to leave everything to their children as well. So of course, there are people who remarry and they leave assets to each other, which is exactly why we might be protecting with a trust on the death of one spouse prior to a remarriage. But back to the situation where the surviving spouse remarries, okay? Let's say the surviving spouse says, well, I'm leaving everything to my kids, but they were not aware of the new law. And the new law would allow the new spouse to make a elective share claim against the estate of the surviving spouse if he or she died first. So our scenario is the surviving spouse remarries, then they die first. If they die first, they're really not aware of the new law. They leave everything to their own kids or their own beneficiaries. We have to be aware that the new spouse could make an elective share claim to get at least 1/3 of everything the surviving spouse had. Now that would obviously be contrary to everything the surviving spouse wanted in his or her estate plan, where everything was going to children or other beneficiaries. So we have to be aware of that. And how do we protect against that? We protect against that because we want to be reminded that a new spouse, if they come onto the scene, the surviving spouse must consider, in theory, should consider and must consider a prenuptial agreement where the new spouse waives his or her right of election. So we protect ourselves with spousal trusts during our lives, during our joint lives, if that's a goal. And then if we ever have a remarriage, we want to think in terms of prenuptial agreement to make sure that we are protecting against a new spouse having an elective share claim. Now, here is the scariest part, which I've shared with many people in our conference room. The scariest part to me is not that the new spouse could do this, because let's say he or she would not do that. They would just never really think of doing that, let's say. But their agent could do it if they were incapacitated. So just know that not only is this a risk if we don't have a prenuptial agreement, but that the agent of the new spouse could make the election. So it's our understanding, and we're waiting to see, that a new power will be in the Maryland statutory power of attorney, which will give an agent the right to make the spousal elective share claim on behalf of a disabled a new spouse. So we are looking for that to be included in the an update to the Maryland statutory power of attorney, but that's something that we're waiting to see whether that's going to happen. On the elder law side of the spousal elective share law, I'm going to be brief here to turn this over to Gary. We are very happy because the state of Maryland has basically put its blessing on a technique that we have long used, which is how to use trusts at the death of a well spouse. So let's say we have an ill spouse and a well spouse, and many of you are aware of these techniques. The well spouse can leave what is called a testamentary trust under a will. It has to be under a will by federal law. A testamentary trust for a surviving ill spouse or a spouse that's not well. And that trust is protected from the claims of Medicaid or nursing homes and as an asset protection technique where there is an ill spouse in the situation. So Maryland has put its blessing on this and says that if the well spouse dies first, which obviously doesn't happen very often, but if that happens, if they leave at least 1/3, and it's a formulaic thing, but it's at least 1/3 plus a little bit extra in the formula that is for legislative purposes, in that trust at their death for their surviving ill spouse, that 1/3, which the otherwise ill spouse would have been allowed to claim, that remember Maryland says that ill spouse has a right to get at least 1/3. Well, now the new law blesses the process of saying, well, if the well spouse dies first and he or she leaves that 1/3 into this testamentary trust, which is usually drafted as a supplemental needs trust, then that 1/3 is not available to the claims of Medicaid or medical assistance in Maryland. And of course, most spouses who pass away first and have an ill spouse, they most of the time leave 100% in that special needs trust. Not always. Maybe that's not going to be the goal. But the point is that we used to have a situation where Maryland or medical assistance would have a claim on a 1/3 spousal elective share amount of that the ill spouse was supposed to receive. And now that is not going to be the case. There's been a compromise legislatively, and it's a wonderful thing that an ill spouse can pass away, leave assets in a supplemental needs trust, including the 1/3 that the surviving ill spouse would have had the right to have, and all of it is going to be protected from the claims of medical assistance for what medical assistance may have paid for the ill spouse when they were in a nursing home under Medicaid. So all that said, that is the augmented estate or legislative update on the new spousal elective share. And I'll turn it over to Gary now, and I'm sending my best wishes to everyone. Gary, we're social distancing here, so I'm going to move away and let you take over.
Hello, everybody. This is Gary Greenwald with some legislative updates with which you all might be interested. First of all, in addition to the very nice summary that Steve gave regarding the elective share, there have been some other developments under the Maryland legislature's actions over this past year. First of all, if you've ever been involved in a probate and the probate closes, and I've had this happen a few times, where a client then calls me after the probate closes and says, hey, guess what? We just received a check. What do we do with it? After all, since the probate closes, it's no longer part of the probate. Now there's a new law that says that for checks under $1,000, as long as a petition is filed with the court and the court approves this, with the court order, you can now take a check under the amount of $1,000, put it into a personal account, and distribute it to the beneficiaries of the estate. Now remember, the beneficiaries can either be the people who are designated as such in a decedent's will, or if there's no will at all, we go by the laws of what's called intestate. When there's no will at all in a probate, the state of Maryland determines to whom the assets in the probate will pass. So with this new law, any interested person, it doesn't have to be the personal representative of the estate, can file a petition with the court, state that a check below the amount of $1,000 has been received, and as long as all the inheritance taxes are paid, and as long as the estate is not insolvent, you can now take this check, again with a court order, deposit it into a personal account, and then distribute the proceeds of that check to the rightful and legal beneficiaries of the estate. As long as, again, there are no expenses or inheritance taxes due to the probate court. Second, and for those of you who have living trusts, I know that there's a lot of you out there who have these, recall that when you pass away, the trust has to be settled. One issue arises as follows. When a person is serving as the trustee of a trust that's being settled, when the time comes for the proceeds to be distributed, I've always counseled, and I'm sure Steve has always done this as well, I've always counseled the trustees who are settling the trust to obtain releases from all the beneficiaries, that an accounting has been presented, everybody's looked at it, everybody agrees to it, and now the assets will be distributed. But to protect the trustee, we always want all the beneficiaries to sign a document or a release which says that yes, we've reviewed the accounting, we agree to it, and as long as the assets are distributed according to the terms of the final accounting, we agree not to sue the trustee later for any purpose. Sometimes, though, that doesn't happen. Sometimes people will actually simply not, for either because they disagree with the accounting or because they are lazy or they never get around to it, they don't sign the release. The new law in Maryland now regarding settlements of trust say that a trustee can send out a written notice to all beneficiaries of a trust stating that an accounting has been filed, here's the accounting, feel free to review it, and if no written objection is filed with the trustee or presented to the trustee within 120 days, then under Maryland law, the trustee is deemed to be released from any further liability or objections from the trust beneficiaries. And assuming that the notice goes out and 120 days has passed with no objection, then the trustee can distribute the funds and not have to be concerned that sometime later a trustee is going to file a claim that there's been some type of incorrect or improper distribution. Thirdly, and I know we've talked about this for clients who've done their trust recently, recall that there's an estate tax. In Maryland, the estate tax exemption is $5 million per person, $10 million per couple. The federal estate tax exemption is around $11.5 million per person and about $23 million per couple. Now, the following only applies to Maryland law. Recall the new law now in Maryland is that a surviving spouse is entitled to use the unused exemption of the first spouse who died. When a spouse dies, there's an unlimited marital deduction. You can leave an unlimited amount of assets to a surviving spouse. But recall also that unless some action is taken, the exemption of the first spouse who died goes to waste unless an estate tax return is filed. Now here's the key. An estate tax return under federal law and Maryland law must be filed within 9 months of the date of death of the first spouse who died. Maryland's new law now says that if you're looking to save this exemption of the deceased spouse, we call that portability. If you're looking to save that unused exemption for the surviving spouse, if the only reason that you're filing an estate tax return is to preserve that portability, to preserve that unused exemption for the surviving spouse, you now in Maryland don't have to file the estate tax return within 9 months of the date of death. You have now 2 years from the date of death to file the return. The only hitch here, and I don't think it's a really significant one, is that although there's a 3-year statute of limitations for the Comptroller of Maryland to audit an estate tax return. The Comptroller now, after the 3-year statute has run, is allowed to go take a look at the estate tax return that was filed upon the death of the first spouse, just to ensure that the return was done correctly. But the key here is now in Maryland, a surviving spouse has 2 years instead of us 9 months to file an estate tax return if the only reason that it's being filed is to preserve the portability. Often clients will come to me when we're designing an estate, and they have certain things they want done, certain prayers said, certain music played for a funeral. And I've generally told clients that unless the only type of instruction you can put that's binding is in your will if you want to be cremated. So what I've told clients is if you want any wishes for your funeral or your burial to be known to your family, sign something, a direction to your family members. Sign some instructions which say, here's what you would like to have done for your funeral or your burial. I've always told clients that these types of instructions are not binding. Well, Maryland passed a new law which says that you can now express your wishes regarding your funeral arrangements in a will or an advance directive or in any other written document. And if you designate somebody in those written documents to take these actions and follow your instructions, they're actually in Maryland required to obligate what you have stated in these instructions and follow your wishes. So now if you do have special things you want to take place at your funeral or burial, as long as they're communicated in a will or an advance directive or another document, these instructions must be honored. My only suggestion is not to put it in your will, because if you change your mind about instructions for your funeral or burial in your will, you'd have to do a new will later. So my thought would be, if you want to provide these instructions to your loved ones, put it in some other type of written document. But the key is, now your instructions must be complied with if you've designated somebody to honor those instructions. Another new law in Maryland is now severe emotional distress is included in the statutory definition of neglect in cases where there's a vulnerable adult or an elderly person. So if one claim you might have against a nursing home or another person who's caring for an elderly adult or a vulnerable adult, simply alleging severe emotional distress is now a cause of action in Maryland. Another significant change under in the Maryland legislature is that now, for the purposes of the Consumer Protection Act, exploitation of a vulnerable adult or an elderly person by a merchant is now considered a violation of the Consumer Protection Act. The significance of this is that in Maryland, for a violation of the Consumer Protection Act, a plaintiff can claim up to treble damages. What does that mean in plain English? You can now allege an amount of damage, and if you can prove it, a court can award 3 times the amount of damages. So if you have a relative or a friend who is elderly or is vulnerable and they're taken advantage of by a merchant, the merchant can now be sued for treble damages, because again, taking advantage of an elderly or vulnerable person is a violation of the Maryland Consumer Protection Act. So between what Steve had said and I had said, that covers the changes under Maryland law that have been passed by the legislature. There have been 2 cases that have occurred over the last 2 years, which might be of interest to you. The first is a case called Barclay versus Castruccio. This new case in Maryland recognizes a claim for intentional interference with an inheritance or gift. My guess is that if you're hearing this, your eyes might have popped up. What does this mean? This means that if you've got, say, 2 children, and one child takes some underhanded actions to try and influence a parent or another relative to cut out the spouse from an inheritance, the child who's not receiving anything, who may have been cut out of an inheritance or a gift, can now sue and recover. So here are the elements of that new cause of action. First of all, the victim, the person who is suing, has to have had some reasonable expectation that they're going to receive an inheritance or a gift. Second, the defendant, that is the person who is committing the wrongs, must have had an intentional, they must have committed an intentional or independent wrong, such as fraud or breach of fiduciary duty, or maybe perhaps trying to influence somebody under duress or undue influence. Third, the defendant's purpose in taking these wrongful actions must have been to interfere with the victim's expectancy of a gift or an inheritance. Fourth, the defendant's conduct must have caused the expectancy to fail. That is, the wrongful action taken by the person who's being sued had to have been the cause of not receiving the gift or the inheritance. Fifth, the victim, the person who is suing, has to have suffered damage. That means the gift, again, or the inheritance has failed. And finally, there has to be no other way, no alternate way of trying to recover these wrongful actions in the probate court. What this means is, and I've had this happen once or twice in my practice, my guess is Steve has as well, is that if a child, let's say, wrongfully tells an attorney that the other child is not entitled to inheritance, or even more so than that, if a child goes to the attorney representing the parent and wrongfully or falsely says that the parent lacks the legal capacity to sign a will, and then presents some false evidence to that case, and as a result, the attorney doesn't draft the will, leaving an inheritance to both children, because that evil child or that wrongful child said something false to the attorney, causing a will to not be written, which might have otherwise left an inheritance to that child's sibling, that is a cause of action against the perpetrator of that wrongful act. The other case that has taken place in Maryland this past year is a case called Plank versus Chernasky. This is a new case that now recognizes as an independent cause of action, breach of fiduciary duty. So for those of you who have trusts, you've designated successor trustees, or for those of you who have wills, and when there's a death, the will is admitted to probate and the personal representative is appointed, the person who's settling the trust or settling the probate is called a fiduciary. A fiduciary is a person who, under the law, owes the highest duty of care to those that's supposed to be protected by the fiduciary. An attorney is a fiduciary, and an agent would be, a real estate agent would be a fiduciary. Now, under Maryland law, a breach of fiduciary duty is considered a separate and independent cause of action. And here are the actions of this new cause of action. First of all, the fiduciary is the person, again, who owes the highest duty of care. The fiduciary duty has to have been breached by the fiduciary. The victim has to suffer damage. And the key here in this case is there's no need to prove any other independent wrong, such as fraud or negligence. So basically in Maryland, under this new case, if a fiduciary falls below the highest duty of care to somebody else, independent of any other wrongdoing, and as a result, somebody is harmed, the fiduciary can be sued. So that concludes the legislative roundup this fall, and also a summary of the two significant cases related to estates.
Well, Steve and Gary, thank you as always for your annual update. Always valuable information. A great job as always. To reach Steve, please email him at steve@elvilleassociates.com or 443-393-7696. And to reach Gary, his email is gary@garygreenwaldlaw.com or at 301-596-2960. So we'd like to thank you for being part of our 2020 Client Event On-Demand video series and hope you enjoy our other content we have available. Have a great day.
Thank you.